from the meanness. Item number 1.
What is this about the?
My lord, this with regard to the my lord, the
Huh? Oh, but, what will happen in the Supreme Court?
Lordship, this matter will come up after some time, some 2 weeks after.
So the stay is not there? Very well. It is submitted by the state that the matter is due to appear before the Supreme Court any time now. Paragraph, since an initial stay was granted by the Supreme Court on January 30, 2023, and the matter had been adjourned in this court accordingly, command let the matter stand over for 6 weeks.
highly obliged, lordship.
Paragraph, the parties will have liberty to mention for an earlier listing upon the conclusion of the Supreme Court case.
My lord. I also didn't tell you.
Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
The state were supposed to file the progress report in respect of the disciplinary proceeding. Well, the state were supposed to report the.
Who are you for?
I'm for the PIL petitioner.
You are for the petitioners.
Well,
What has happened in the disciplinary proceedings?
Lordship, as per order dated 36/2023, the PO had applied for earned leave, Your Lordship, and his earned leave is still 37/2023, that means ending July. Before that, Your Lordship, the case, the DP has proceeded, except because the PO is on leave and is joining on 37, so we are held up on that part. And so far, Lordship, this is so far the DP is concerned. So far, criminal cases are concerned, Your Lordship, in 3 cases, we have got the prosecution, and most of the case are in advanced stage, like as per information received, Your Lordship, within next
Charge sheet filed?
within next 10 to 15 days, in some cases, charge sheet have been filed.
It does not appear that much progress has been made in the disciplinary proceedings pertaining to the 7th respondent. Full stop, the state says that since the
PO, presenting officer,
presenting officer
he is on earned leave till 37 2000.
was on leave, the matter was stalled. Full stop. It is hoped that the matter will be proceeded with in right earnest, as expeditiously as possible and in accordance with law. Paragraph. As far as the criminal cases are concerned, the state says that the investigation is at an advanced stage and charge sheets are likely to be filed within the next fortnight or so. Paragraph. Let the matter appear 4 weeks hence.
Pleasure.
For the state to file a report both as to the status of the criminal proceedings and of the disciplinary proceedings.
Item number 2.
On the last occasion, I have taken time to go through the comparisons of the judgments given by the merit. But only 2 aspects, my lord, in this matter.
Yes.
Firstly, my lord, after this, their appeal was allowed by the sestate in the first round of litigation, my lord.
After the appeal was allowed?
In the first round of litigation, they filed an application. It appears under section 35F. My lord, and that is reflected.
They filed an application under 35F.
For interest, my lord.
For?
For interest, payment of interest. Now the question is only about payment of interest, my lord. The principal amount has been refunded to them, my lord.
The simple view which is taken,
My lord.
is that the payment that is due to them is not on account of any refund or duty, refund of duty or interest. So if it is not on account of refund or duty or interest, then the embargo does not apply, and therefore they are entitled to interest, and which is a view we are upholding.
Lordship. My lord, lordships on the last order have said the interest on interest, my lord. My lord, that, my lord, the Supreme Court, my lord.
But that is what you are guilty of.
My lord, interest on interest is not permitted, my lord. There's a decision by the Supreme Court, my lord.
Let us see.
My lord.
There is no absolute proposition that interest on interest is not permissible. If you are liable to pay interest 10 years back and you don't pay it.
My lord, in Sandwich Asia, which they relied on, my lord, for claiming interest on interest, my lord. In this case, that has been clarified, my lord. That
Anyway, we are not saying anything.
my lord.
We are just giving them free.
Lordship, this,
Very well.
That is one aspect, my lord. Secondly, my lord, in their comparison, the next judgment of Delhi High Court, my lord, where the interest was awarded at the rate of 6%, my lord. In the present case, the interest was awarded at the rate of 12%, my lord.
At
12%, my lord.
that is their discretion. We will not interfere with it.
My lord, lordship, kindly have a look at, because even the facts are identical, my lord, in the Delhi case, my lord.
Maybe. Courts are very, judges believe that awarding interest is like breaking a rib and giving it.
My lord, because, my lord, going with the circular, my lord, at page 66, it's the rate of interest is prescribed by the notifications, my lord.
Yeah.
And at the relevant point of time, the prescribed rate of interest was 6%, my lord.
The appellate tribunal will know it better. The appellate tribunal would have known it better. The appellate tribunal has granted interest at that rate. We don't want to interfere, either with the principal or with the quantum. The facts have been,
So page 66 was the notification. That has not been dealt with.
may not have been. The facts have been recorded in detail in the previous order of July 11 to 2023 and may not warrant repetition, full stop. However, since the appeal is proposed to be disposed of by this order, is there a delay?
there's a,
Is proposed to be disposed of by this order, some facts
There's a delay, my lord.
are referred to, paragraph. At the outset, the delay of about how many days, Dr. Muzika?
Lordship, 243 days delay against the main order and against the ROM order, 43 days delay.
The delay of 243 days against the main order and 43 days against the subsequent order delays are condoned in view of the good ground shown. The legal issue that has arisen here is as to whether the respondent SSE was entitled to any interest on the delayed refund made by the department, whether or not such refund has already been made. Refund has been made.
Lordship, refund.
Then whether or not there should not be there, full stop before that. There is no doubt that Section 11B of the Central Excise Act 1944 does not provide for any payment of interest or refund of duty or interest. Full stop. However, the moot question here is whether the refund that the respondent SSE was found liable to was on account of excess duty or interest paid. Full stop. Paragraph. Since it is the inarguable position that the refund that the SSE was found entitled to was neither on account of excess duty nor on account of interest previously paid, comma, the appellate tribunal held that the embargo of interest, that the implied embargo on interest in section 11B of the Act would not be applicable. Full stop. Paragraph. The department initiated an investigation against the SSC on the ground that the SSC had claimed excess SENVAT credit. Full stop. However, comma, even before a show cause notice or any demand was issued, comma, the SSC deposited a sum of about rupees 94 lakh under protest. Full stop. Indeed, comma, the deposit was made by reversing a further SENVAT credit to such extent which amounts to almost payment in cash. Full stop. A show cause notice and a subsequent order in original followed. Full stop. The SSC was found entitled to claim refund SENVAT credit. The SSC was found liable to refund SENVAT credit to the extent of rupees 97 lakh. Full stop. The SSC challenged the order before the tribunal, and the tribunal found that the demand for excess SENVAT was good for about rupees 16 lakh. Full stop. After providing for interest and penalty on the excess amount of SENVAT credit availed, comma, the tribunal found that a sum of approximately rupees 78 lakh was liable to be refunded by the department to the SSC out of the deposit of about rupees 94 lakh that had been previously made by the SSC. Full stop. Paragraph. It appears that the department had no quarrel with the quantum of refund as directed to be made by the tribunal. Full stop. It is also the admitted position that the amount has been refunded. Full stop. The SSC, however, contended that since the excess amount, that had been deposited under protest, was retained by the department for a considerable period of time, and such deposit was neither on account of any SENVAT credit demand or on account of any claim for penalty or interest, the refund that the SSC was found entitled to, ought to carry interest, full stop. The paragraph. The department refused to pay any interest as the Central Excise, Sales Tax and Sales Tax Appellate Tribunal had not provided for any interest in the appellate order. Full stop. The SSC again knocked at the doors of the appellate tribunal to claim that the refund that the SSC had received ought to have been paid with interest. Full stop. The legal issue was that the possible embargo that is read into the payment of interest on account of refund of duty or refund of interest or the like in section 11B of the Act would not apply when the initial deposit had not been made on account of any interest or duty, but had been made purely as a deposit and under protest. Full stop. In course of the paragraph. In course of the appeal before the SESTAT, several judgments were looked into, full stop, by the order impugned dated April 11, 2022. The tribunal recorded its satisfaction that the refund in this case was not of any duty or interest on duty, full stop. Accordingly, the tribunal found that the SSC was entitled to interest, full stop. On the quantum of interest, the tribunal relied on a Supreme Court judgment passed in an income tax matter to arrive at the figure of 12% per annum. Full stop. The paragraph, the department sought a review or a correction of the relevant order and, as it stands today, neither has the interest, as it stands today, the interest amount required to be refunded, required to be paid by the order dated April 11, 2022 still remains outstanding. Full stop. Paragraph. The department claims that since the initial deposit had been made in anticipation of a claim for excess SENVAT credit availed of, such deposit must be understood to have been made on account of duty and, accordingly, the bar under section 11B of the Act would apply. Full stop. The second ground urged by the department is that in similar circumstances, the Delhi High Court has awarded interest at the rate of 6% per annum, and notifications that were relevant for the purpose of assessing the quantum of interest also provided for interest at or about the rate of 6% per annum. Full stop. Paragraph. The tribunal has given adequate reasons in both the orders impugned, including the order by which the department's application for correction or modification was rejected. Full stop. According to the tribunal, the deposit was made at a time when no quantified claim had been made on the SSE. Full stop. On such basis, the tribunal found that the deposit had not been made on account of any duty or interest which would attract the implied bar under section 11B of the Act. Full stop. It was a possible view taken on the set of facts that presented themselves before the tribunal and, in this appellate jurisdiction, such interpretation does not call for any interference. Full stop. Further, as to the quantum of interest awarded, the tribunal, which is a specialized body dealing in matters pertaining to excise duty, found that a Supreme Court judgment on refund of money to the SSE with interest at the rate of 12% per annum would apply in the facts of the present case. Full stop. Again, since the award of interest, since there is some basis to the award of interest by the appellate tribunal, the same does not call for any interdiction. Full stop. Paragraph. Accordingly, the judgments and orders impugned dated April 11, 2022 and
28th October 2022.
October 28, 2022 are allowed to hold the field as they do not call for any interference. Full stop. MC Central Excise Appeal bracket number 1 of 2023 is disposed of. The main appeal, whatever the number, is dismissed. Full stop. There will, however, be no order as to costs. Full stop. Just one paragraph. Insert it just before. I'll tell you where to insert it. A further contention has been raised by the department, possibly, in the light of the discussion on such aspect in the immediate previous order of this court of July 11, 2023, that at any rate, interest on interest would not be payable, full stop. However, there is no question of going into such area at this stage, since it may not be relevant. Full stop. Suffice it to say that since interest is a mode of compensation, it may not always pass muster to delay the payment that is due and claim that notwithstanding the reason for the delay or the extent of the delay, no interest on interest can ever be payable. Full stop. Be that as it may. Then disposed of.
Lordship,
A
just one.
small correction will be required, my lord. The Supreme Court decision only granted 9%, my lord, not 12%. Other such decisions are awarded 12%.
Supreme Court taking into cognizance, Supreme Court ordered 2 rates, 9 and 12 in certain situation, and then it was followed by other High Court judgments and other tribunals. And latest, the larger bench of the tribunal also ordered 12% in similar circumstance.
Very well. Where I've said Supreme Court judgment 12%, they're taking into account previous judgments of the Supreme Court, High Court, and the same tribunal.
Lordship, one interference, Lordship, a time limit may be fixed for the compliance, Lordship, because we are seeking interest from 2012.
We'll fix the time limit as long as you give up your claim for interest on interest. Give up the claim for
Lordship,
We'll record that.
Lordship, we are giving
After this order is pronounced, the SSC says that if a direction is issued to the department for immediate repayment of the amount due
from the date of deposit, Lordship. From the date of deposit, because that is important, Lordship.
amount due from the date of deposit, no claim for interest on interest will be made, full stop. Paragraph, without going into the question as to whether any claim on interest, any claim for interest on interest can be legally pursued, the department would do well to make the payment due, make the payment of the interest due within 4 weeks from date, full stop. If the payment is made within such time, there will be no further claim of the SSC in respect of this matter, full stop. Otherwise, the SSC will be entitled to pursue any remedy available in accordance with law.
Grateful to you, Lords.
Any further remedy.
With the cause title, the spelling of the SSC is incorrect. In Valley, that is VALLIEY.
Just correct it in the first title. Yes.
Grateful to you, Lords.
Right.
Item number 3.
Lordship, at the very outset, my lord, I beg to tender my apology for the inconvenience on the last occasion, my lord, because for the emergency I could not be present. I tender my apology for the last occasion.
You are Bernard or you are the other
Bernard,
one?
my lord, responding
You are
one.
Bernard. And the other one, what is he called?
Bonnie, my lord.
Bonnie. Bonnie is the uncle.
Lordship. Yes, yes.
From what we remember,
PW 18, Your Lordship. PW 18,
from what we remember, is that there is no certainty as to the murder weapon.
My lord.
Lordships.
There are two statements of the two accused which cannot be used against each other,
My lord.
but can be used against himself.
Yes.
What comes out from the two statements is that, and for that, the ambit of circumstantial evidence becomes limited in point of time. Whether they were seen on an auto together, whether they were seen drinking in that hotel together, whether in, where was it, Maulai?
graveyard, Your Lordship. Graveyard.
Ultimately, it comes from the independent statements of the two without using one statement against the other,
Absolutely correct.
that the three of them were in the graveyard.
Only my humble
Bernard says that he went out for a cigarette.
Lorships.
And when Bernard came back, he found Bonnie strangling the victim. Had already strangled the victim. Bonnie says, no, he was ill after drinking at the last place. He vomited and then he put his head on my lap and passed away.
Absolutely correct.
Just from memory.
Lordship is correct.
Possible. It can happen. We are not discounting that. However, the post-mortem examination reveals that death due to strangulation.
Lordships.
Forget no rope found, forget nothing. When A and B are together with C and on their own individual admission, they are the only persons with C. When an unnatural death occurs to C, under 106, they are liable to explain how the victim meets the unnatural death. Bonnie's statement is found to be a lie because he says, put head on the lap. Why does the postmortem report say strangulation? No attempt to discredit the postmortem report. So we have to go by that. That's gospel. Bernard may or may not have been there. We will not use the statement of Bernard to say what he saw to convict Bonnie. And in the absence of Bernard's statement, we do not know when Bernard went, when Bernard came back. But what we know was that there was a common intention. There is 34 over here.
My lord, 34 charges were never framed.
34?
Charge
Was
sheet
not
was
there?
filed, charges were never framed under 34.
34 was not there?
No, Lordship.
Very well. Then, at least Bonnie gets
If I may only humbly,
gets murdered, and Bernard, we have to find out what will
if
happen.
I may humbly submit a few points, my
Regarding
lord.
Bonnie also, there we are disputing the statement made under section 164 of CRPC, and that my
Where have you disputed that, madam? Have you disputed that in your
before the
313?
trial court, my lord, in 313.
Yes.
Question number 15, my lord.
Just place it, madam.
Yes, my lord.
In fact, both the accused say, my lord, that they have not made any, they have denied all the questions, but
164 was before a judicial magistrate.
it was before a
My lord,
judicial
before the
magistrate, my lord.
A judicial magistrate has come and
She has been
deposed.
examined, lord.
PW 31.
Was they cross-examined?
Lordship,
Lordship,
yes.
yes.
And in the cross-examination, what has come? There is first a
Absolutely.
presumption of the judicial magistrate has no axe to grind.
My lord, in
why-
this particular case, there is one aspect which needs to be considered by this honorable court. It's that the judicial magistrate first class who had recorded the statement under section 164 of both the accused persons is the same person who was present at the time of exhumation of the dead body. So, my lord, the entire circumstances of the case was very well within the knowledge of the judicial magistrate. And the section 164 statement has been recorded by herself.
In question answer. Additionally, my lord, the learned trial court also opines that in fact there was no confession at all. What lordship has said, my lord, that they have admitted to have been in the graver at the same point of time.
No, confession depends on, there is no confession of murder.
Lordship, yes.
But there are certain statements which are made. There are, you say 10 things. For instance, you say that it was a Monday. You say that it was in the evening. You say that it was in the graveyard. You say that the three of you were there. You say that he died in a particular way. So all of them have to be seen together.
Yes, but
so the effect of the individual components of your statement, to the extent that you do not, you are able to dislodge them,
here, my lord,
have to be held against you.
In my humble submission, my lord, the proposition of law as it is that, my lord, if the confessional statement contains some parts which are exculpatory and some parts which are inculpatory. Self, my lord, I am not on the self-inculpatory and self-exculpatory, my lord. It is not, the prosecution is not at liberty, my lord, to sever it, my lord. They either have to take the entire statement as the truth. There are judgments to that effect.
That is not it. That is not it.
My lord,
There are
on
certain things.
exculpatory confession, I have. My lord,
You said
313,
question
my
number
lord.
15.
Question number 15, my lord. The 313 statement was recorded in Khasi, but a translated copy is available in the paper
Yes.
book.
Tell us, what did he say?
My lord, the question is, MB Shalam, Srimati MB, page number 365 of volume 1.
Yes, we come to that. We are not looking at the papers now. We're just
No, madam.
indicating to you. We're just indicating to you which direction our mind is going, so that you can face it, so that you can reply to it adequately.
Yes.
Yes.
Srimati MB Shalam magistrate stated in her evidence that she recorded your confessional statement on 9/3/2006. What do you have to say? The answer by the accused person, Bonnie, I was produced before the magistrate who asked me, and I have stated that I want to confess the truth. Then I was kept there in the courtroom for a very long time, and when it was to get dark, the magistrate asked me to sign on a paper and thereafter reply me to go. And I did not get to tell or confess anything at all.
Unbelievable statement.
But then, my lord, there is...
Unbelievable statement.
My lord, will...
Very well. What is your cross-examination of of the magistrate?
It's page 318, Your Lordship.
Yes.
318
Let us see what is the cross-examination. Read the cross-examination part.
Cross was conducted by...
Cross for Bonnie.
Bonnie is at 317, my lord.
Yes.
I do not remember whether Exhibit 4, the inquest report, was prepared in my presence. In Exhibit 4, my signature is appearing as a witness, and Exhibit 4D is my signature. Lord, when the witness...
Forget it. Where is the question on confession?
My lord,
Cross-examination.
I do not agree, as I am a witness to Exhibit 4. I am not competent to record the statement of the witnesses or even that of the accused persons in this case. I agree that as a witness to Exhibit 4, I am substantially aware of the facts and circumstances of the case. At the time of holding of the inquest of the dead body of the deceased, only one accused is present, and that is accused Sri Bernard Lingdorf Hawa. I cannot remember now exactly. Witness then says that Exhibit 4 was prepared on the spot. I do not know any of the witnesses personally in this case whose statement I have recorded. No one has identified the said witnesses to me, but the witnesses themselves identify themselves to me at the time of recording their statement. It is correct that Exhibit 20 confessional statement of accused was recorded on 9/3/2006. On being shown the order sheet of the case record today, I say that there is no order dated 9/3/2006. it is not correct to say that in the statement Exhibit 20 of accused Boni Bhawa, I have incorporated my own knowledge of the case on a later date. It is also not a fact that Exhibit 20 is not the correct version of the accused person. It is correct that Exhibit 20 reflects the signature of the accused with a date thereon as 8/3/2006. My lord, there is no order sheet of 9/3/2006. There is no signature of the accused on 9/3/2006. But the magistrate has signed on the confessional statement on 9/3/2006. This is, my lord, highly disturbing.
Nothing.
Because, my lord,
Not disturbing at all, madam.
my lord, at least the order sheet would have been there if the confessional statement would have been recorded on that
He
day.
signed on 8, she signed on 9. There's no difficulty. She takes responsibility for that. There's no question put to her that I did not make a statement and you recorded it.
My lord, the witness has stated that it is correct that Exhibit 20 of accused Boni was recorded on 9/3/2006. This is the statement that I recorded the statement on 9/3/2006.
Yes.
And there is no order sheet of 9/3/2006. And the accused,
Mistaken date does not. Where is your question to her that I did not say anything? In 313 to question number 15, you say that I was taken over there. Then for an inordinate time, I was asked to wait. What that shows is that what the magistrate gave you was time for reflection.
yes, my lord.
All right.
Agreed.
And you say that it was about to be dark. I did not say anything. I was asked to put my signature at the end of some paper in which she had written something. So where is the corresponding cross-examination by you of the magistrate?
My lord,
And we cannot take a murderer statement and give it preference over a magistrate statement.
one more aspect, my lord, not on the magistrate's part, but on the post-mortem part, my lord. The post-mortem was conducted on, my lord, 22nd of February 2006.
Yes.
And the post-mortem report, it shows that the death had taken place approximately, my lord, if I'm not wrong, as
24 hours. 48 hours.
48 hours. 48 hours
Very
prior
good.
to that.
48 hours before that.
So, my lord, the death ought to have taken place
22nd?
on 20th. From 22nd, if we count 48 hours prior
22nd or 24th, you said? 22nd.
22nd, my lord.
20th, yes.
20th. But, my lord, on 20th, Boni could not have murdered the victim. Reason being, Bernard was arrested unofficially on 19th and arrest memo was prepared on 20th. On 19th or 20th itself, Bernard had disclosed the name of Boni, through which the police came to Boni. Boni was also taken on 20th, my lord. So, my lord, if the accused person is with the police on 20th,
Anyway,
then how can the victim be murdered on 20th?
That goes away by your thing. The postmortem report always gives an approximation, and approximation, was the doctor questioned on this aspect? How long before the postmortem examination? Let us see that line of questioning.
I'll just see which witness is the doctor. No, it's not three.
PW2.
Postmortem conducted by him. PW2. Statement across, my lord, page number 103.
Yes. Was he questioned that whether it was 48 hours or how much approximation is made? We know that there are approximate times.
Yes,
It can be 12 or 24 hours plus minus.
cross by Boni.
Yes.
Before conducting the post-mortem, I have gone through Exhibit 4. Injuries mentioned in Exhibit 4 are almost same, which I have found in the body of the deceased. In the instant case, I found hyoid.
Exhibit 4 is the postmortem report.
Exhibit 4 is inquest report, my lord.
Inquest report.
In the instant case, I found hyoid bone, both sides of the deceased was found broken. When the hyoid bone is broken, the cause of the death may be by strangulation,
Yes.
suspending the body, which is as otherwise called by hanging. It may be a case of suicide by hanging in the instant case. In the instant case, larynx of the deceased was intact. then the larynx is not broken. It may be or may not be a case of strangulation. Externally, I have not found any blood clot in the nostrils, ears, or mouth of the deceased. I have not found any cyanosis of nails or face of the deceased. Cyanosis of nails bed and blood clot in the nostrils and ears are common symptoms of strangulation. But these are important aspects which the expert witness has given us.
Then go on.
I have not examined the windpipe of the victim. I have dissected the neck region of the deceased and found that hyoid bone on the other side is broken. I have not opened the skull of the deceased. Usually, skull is to be opened first before dissecting other organs of the deceased. The body of the deceased was reviding levo mortis. The body was fit for examination. Those furrowing of the neck and the bare of the furrow was thickened from there. I could ascertain the ligature are ante-mortem in nature. I have not mentioned this finding in my report. I have not mentioned whether the ligature marks are old or fresh in nature. It was not shown any object by which the ligature marks could be made on the body of the deceased. It is not a fact that the ligature marks which I have found in the body of the deceased are not ante-mortem in nature. If the ligature is caused by any rough object, there would be a damage in the outer skin or epidermis. It is not a fact that my examination is very casual in nature, and from my report given in Exhibit 8, actual cause of death cannot be ascertained. I have not sent the viscera for examination. The stomach region I have examined and found healthy, but I have not written anything about the contents of the stomach region. It is not a fact that the deceased took alcohol and he is under the influence of drugs. My lord, the stomach has not been examined. The
He
contents
does
of
not
the
find that evidence. He does not find that evidence. Go on. Where is
that is the
your
problem.
question
In fact,
about the time of death?
What my learned friend is trying to say is has been born in the chief examination, my lord, not in the cross.
Yes, what is there in the chief?
She says, my lord, there's a line in page 101, my lord, in the chief. She says, my lord, that in my assessment, the time of death of the victim had been about 2 days or 48 hours prior to the conduct of the postmortem. Postmortem being conducted on 22nd at 11.
22nd. So it happened on 20th.
20th, my lord.
That's in his judgment and about. So it could have
If we
been a
take
bit
about
more.
also, my lord, we can prepone it by one more date, maybe. We take it on 19th of February.
There's no English word called prepone.
Sorry, my lord.
It's now in the appendix because of Indian usage of it.
Why?
Because in the word postpone, post is not a suffix. Postpone is a word by itself.
My lord. But
Yes.
even if we take it to be not 20th and even if we take it to be 19th of February, then also the victim had gone missing on 18th of February, my lord. 19th of February, the search by the informant along with the friends of the victim, which included Bernard, had started on 19th, my lord. And Bernard was a part of the search team. And another important aspect in this particular matter, my lord, in the entire team of friends, there was one boy by the name David. Now, in the statement of the informant, PW1, it's that they,
Sorry.
no, on PW1 states that they went to Laban to try to get the mobile phone of the victim recharged, prepaid number. Now, my lord, and thereafter he said that we could not recharge the mobile phone because it could only be recharged by the person with whom the phone was. Lord, at that point of time, the scratching card system was there. Online recharge and all was not there in 2006. So that might be one of the reasons, the top up. It could not be done. David was a part of that particular team, my lord. But subsequently, it has been found in one of the statements that the mobile phone of the victim was with David. That is at page 90, my lord. This has been stated by the police, PW9. PW9, page number Sorry, my lord. Page 90 is the statement. Page 90 is the
Just
statement.
without reference to that, just tell us what is the significance according to you?
Significance is, my lord, David has neither been examined as a witness before the court. When the mobile phone was in possession of David, why did he not disclose it?
Why did who not disclose it?
David. He was one of the friends of the victim, my lord.
Yes.
And he was a part of the search team. They were trying to find where Biplab was. Now, when David is a part of the search team, the victim's mobile phone is with him. He is going along with the informant to get the mobile phone recharged. Why did he not state that the victim's mobile phone was in his own possession and it was not with the victim? Why did the police not examine David, who was a part of the search team? He has never been produced before the court, my lord.
Is there any evidence to the effect that the victim had the mobile phone on him after he was allegedly abducted?
My lord, there is no proof of that.
In fact, it is to the contrary, because the victim, after he is allegedly abducted, had made calls to some of his friends through a PCO, my lord.
Through PCO.
Through a PCO,
So
and
it
in
may be
fact,
presumed that-
Nirvika Singhania, my lord, this entire case, when the FIR was lodged, the case started with the theory of last seen theory. The last seen theory was on the basis of the statement of PW5, that is Nirvika Singhania. Now, when the FIR was lodged, they said that Nirvika told that Bernard was last seen with the victim in Police Bazaar on 18th of February. When PW5 came to the dock and she gave her
She
testimony
never
before
came to the dock. She went to the
she came
box.
before the court, my lord.
Box.
Box, my lord.
Dock and box are different.
I'm deeply obliged, my lord.
Yes.
So when she deposed before the court, my lord, she herself has stated she received a phone call from the victim on 18th February 2006 evening, and the victim...
From a PCO.
Yes, my lord. From a PCO, from a landline number, she received a phone call, and the victim told her that I will not come to pick up my laptop from you today. I am out with my friends who have come from Siliguri, and she has also given the name of the friends from Siliguri. One of the names is Sumit. As far as I remember, one of the names that was mentioned was Sumit. Now, my lord, the police has never tried to investigate from the father of the victim as to whether the victim had any friend by the name of the name mentioned by Nirvika. Police never went to Siliguri to meet those friends, if at all they had come to Shillong and met the victim. Now, this entire aspect of the investigation and the trial, my lord, it will be absolutely clear if I may be permitted to read the judgment before this honorable court, my lord. Everything has been discussed in detail, my lord, every single aspect.
How did the statements get made?
Which statements, my lord?
The two statements of the two 164 statements of the two accused.
My lord, we don't know whether it is true or false, but a section 164 statement
Why should a magistrate
My lord,
record a false statement?
I agree. My lord.
The duty, the responsibility given
It's very huge, my lord.
to a magistrate is so that it's independent. Now, why would what would be her motive?
There is
You have not
there is
questioned
no-
her on that
My-
ground.
My lord, I may only be
You
permitted.
are absolutely right, madam. All the other things are very shoddy.
And
And the only thing, that's why we were trying to eliminate everything. All the things on which you can pick holes, we are eliminating everything. And we are concentrating only on the 164 statement, and what is evident from the 164 statements is that the three of you were at the graveyard together. One makes a statement which cannot be considered under section 30. The other makes a statement which is contradicted by the medical report.
My lord.
Therefore, the consequence is obvious.
My lord is well aware, my lord, in fact, that when we argue and appeal against a conviction before the Honorable High Court, the ambit of the argument and relooking into the entire evidence is very, very huge, my lord. And this court has got enough power to interfere with the entire
No. That's why
judgment.
we are eliminating everything else.
But my lord,
The rest, according to us, is irrelevant. It shows shoddy investigation, no doubt. But the rest is irrelevant. When we have this fact, A saying, yes, I was in the graveyard with him. B saying, yes, I was in the graveyard with him.
my lord, before
That, what happened, everything else becomes irrelevant.
I take your lordship to the judgment, I may kindly be permitted to place only one judgment before this honorable court. The year is 2000, volume 4.
What is it about?
My lord, it is the power of appellate court in appeal against acquittal. And my lord, I will rely only on one paragraph, paragraph 21. The list of books had been submitted.
Yes, tell us.
The principle to be followed by appellate courts considering an appeal against an order of acquittal is to interfere only when there are compelling and substantial reasons for doing so. If the order is clearly unreasonable, it is a compelling reason for interference. The principle was elucidated in Ramesh Babulal Doshi versus State of Gujarat. While sitting in I read the quoted portion, my lord. While sitting in judgment over an acquittal, the appellate court is first required to seek an answer to the question whether the findings of the trial court are palpably wrong, manifestly erroneous, or demonstrably unsustainable. If the appellate court answers the above question in the negative, the order of acquittal is not to be disturbed. Conversely, if the appellate court holds, for reasons to be recorded, that the order of acquittal cannot at all be sustained in view of any of the above infirmities, it can then, and then only, reappraise the evidence to arrive at its own conclusions. That is the reason, my lord, I was harping upon reading the judgment before this honorable court, my lord.
We find that the trial court has dwelt on irrelevant considerations leading up to, and if you see 20 mistakes leading up to the time that they were at the graveyard, you get influenced by this. All that becomes irrelevant. How they go to the graveyard. What becomes relevant is what happens in the graveyard. Both of them say that we were there. One of them gives an explanation which we don't use against the other. The second gives a palpably false information,
But there is no
which
proof
is
of
belied by the postmortem report. Everything else in this matter is irrelevant.
If I may only submit on this particular issue, my lord, as I was saying earlier, my lord, that the position, my lord, if I may just read, I'll of course trouble your lordship with the judgment much later. I'll just read out one paragraph of a judgment, my lord, which was decided in 1965, still holding, my lord, still holding field, Supreme Court, my lord. What they said, my lord, is that no state, if I may just read, my lord, no statement that contains self-exculpatory matter can amount to confession.
What is the difference between inculpatory and exculpatory?
My lord, inculpatory would mean that I am admitting, my lord.
And exculpatory?
That I have washed my hands from the crime, my lord. So if I may just continue, my lord, that no statement that contains self-exculpatory matter can amount to confession if the exculpatory statement is of some fact which, if true, would negate the offence alleged to have been
Very good.
confessed.
Tell us, which part of Bonnie's statement negates the offence?
The part that he says, my lord, that of course it's for her to satisfy, but I'm only trying to say, my lord, that if the accused, one accused says, my lord, that yes, both the accused say we were there at the graveyard, my lord.
So therefore, that is confession.
That is-
Nothing exculpatory about it.
My lord, that is an admission, my lord. It is not a confession.
Well, admission is the best form of proof.
My lord, if I may just read one more line.
Confession is commission of the offence.
Lordship, yes.
They don't confess to committing the offence.
Lordship, yes.
But they admit to being present at the place of occurrence.
Lordship, yes.
All right? Now, Bernard says something which we exclude by applying the rules of evidence. No, Bernard says he has seen Bonnie do it. We exclude that. All that we take is Bernard has not said anything exculpatory which we can ascertain to be as a fact.
What I'm trying
Nor has Bonnie said anything exculpatory which can be ascertained as a fact or established as a fact. Bonnie says, I was there. Bonnie says, victim was with me. Bonnie says, victim put the head on my lap. And then victim passed away.
Lordship, yes.
Postmortem report says, victim was strangled.
Lordship, yes. No, my only point of submission was, my lord, that even if there is an absolutely incriminating admission, my lord, that in the confessional statement, my lord, if that admission is to be taken into account, my lord, the entire confession has to be taken into account.
Yes, we are taking the entire confession into account of Bernard, but we are excluding that which by law has to be excluded by 30. No, but we are taking the entire statement into account. But by virtue of 30, we have to exclude that part.
No, my lord, if we are excluding...
No, sir. You don't know anything about exculpatory inculpatory.
I may be allowed to place...
Oh, you place whatever you want to place. You are hanging.
My lord had just now posed a question regarding the value of a confessional statement and as well as the value of an exculpatory statement, my lord. I'm relying on a Guwahati High Court.
We'll go to law later. We'll go to law later. We'll give you every chance. But tell us on fact. Tell us on fact. Give us a theory which will make us believe that there is reasonable doubt in...
If I may take your lordship to the IO's statement, my lord.
Forget the IO statement. Just think of something. The three of them together in the graveyard. IO was not there.
My lord, that is also not proved because
That is proved by their own admission.
my lord, if I may humbly submit, my lord, section 164 statements are merely corroboratory in nature, and this entire statement has nowhere been brought on record in the evidence.
They corroborate each other.
My lord, those statements are
They
not.
corroborate each other.
Once it is exculpatory, my lord.
Where is it? Do you know what exculpatory means?
Exculpatory means, my lord, if I am trying to state that the other person has committed.
Exculpatory means you're extricating yourself from the commission of the offence.
My lord.
Now, where is that? What is exculpatory in Bernard's statement is something that we cannot take cognizance of by reason of section 30. There is nothing exculpatory in Bonnie's statement. Show us what is exculpatory in Bonnie's statement. That put his head on the lap and died. That is the exculpatory part. That is proven to be false
My
by
lord,
medical examination.
medical examination, my lord, it says that death might have occurred 48 hours, 19, 20 we count. But the victim had gone missing on 18th, my lord. 18th. So the question of medical examination supporting what Bonnie says, that gets divided, my lord.
On 19th,
Contrary.
on 19th,
The FIR was lodged.
on 19th, the FIR is lodged. He goes missing on 8th. Next day, it's lodged the next day. On 19th evening,
Bernard was with the police.
on 19th evening, Bernard was with the
Bernard
police.
was with the police.
Since the morning.
Since morning, my lord.
And in their 164 statements, when do they say they were in the graveyard? On 18th.
18th, my lord. 18th, they say that they were even if we even if we assume that the three of them were together, it was on the 18th. According to the post-mortem, the death took place 48 hours prior to post-mortem. Post-mortem on 22nd, 48 hours prior, 20th. Even if we take a day more in advance, 19th, at the most, my lord. We cannot count more than 72 hours, my lord. And on 19th, Bernard was with the police, my lord. So the question of the murder having taken place or at the time when all the three were together is completely secluded.
How is this part dealt with in the trial court's judgment? The post-mortem report indicating the time of death?
They have held it in favor of the accused.
No, let us see how it's dealt with. This is one point which is capable of demolishing beyond reasonable doubt.
Lordship, it's not only 48 hours, it's 2 days, 48 hours. 2 days and 48 hours.
2 days or
2 days.
Yes, or 48.
No, of
That's a typographical error.
No, that's not 2 days or 48 hours. That will take it as that. And when one says 48 hours, one can give leeway for another 24 hours. But on 22nd, to imagine on 18th that it would have been committed. See, Mr. Khan, we don't have to fill up.
No, absolutely correct.
If it's bad investigation, it's bad investigation.
Lordship, yes.
Para 47 of the
Yes,
judgment,
just read it out,
post-mortem
madam.
starts.
Yes.
Further, as per evidence of PW2, he had stated that he had conducted the post-mortem on the dead body on 22nd February 2006 at 11 a.m. and that as per his assessment, the time of death of the victim has been about 2 days or 48 hours prior to the conduct of the post-mortem. And if it is taken into consideration, then the accused might have, it should have been victim.
Victim, yes.
Victim might have probably died on 20th February 2006 and not 18th February 2006
Now,
as
tell
per
us,
the claim
madam,
of the
what
prosecution.
time of the day was the postmortem conducted?
22nd February.
What time?
Morning 11 a.m.
And when was the body exhumed?
Exhumation, my lord, it was
21st?
21st, my lord.
In the evening?
My lord.
Maximum it will take them to 19th evening. And 19th evening, their body is already, Bernard is already with the search party.
coupled with the fact, my lord, that my lord, we submit that the dates in this matter are of some importance, my lord, because the last seen theory is also based on the PCO and the ransom call.
When do they take place? The PCO?
19th, my lord. 19th, lordship.
When does that lady say that she received a phone call?
No, my lord.
The
What-
father of the victim, my lord.
No. That's
there
a ransom call.
Yes.
Some Singhania or someone.
That was 18th evening
That was 18th evening.
from the PCO, my lord. The PCO owner was never examined. He could not identify any
And
of them.
according to the investigation, they say that the phone call was made from Guwahati.
No, that is the ransom call, my lord.
The ransom call was made from
On
Guwahati.
19th. And the auto driver who says that the two accused went in his auto to the
No,
Maura,
he
my lord.
never says two accused. He says that 3 tribals and 1 non-tribal
He has
went in my auto.
He has identified the accused, so I will not, my lord, press on that. But he hasn't identified the deceased. In any case, that is on 19th, my lord. So that is why we submit, my lord, that the dates have some bearing, lordship.
19th, which means that this is in sync with the postmortem report. If you give the postmortem report some latitude, you have to give it some latitude.
Ma'am.
It was conducted at 11 o'clock in the morning.
Yes, ma'am.
So 48 hours, we'll add another 12 hours before that.
Yes,
It could have been 19th evening.
Yes.
19th evening, do you have alibi?
My lord, 19th evening.
19th evening, I was in the custody, my lord. Bernard, as far as.
What time?
Since the morning, my lord. 9 a.m.
19th morning, you were in custody.
9 a.m.
9?
9 a.m. of 19th morning, I
You were
was
taken
in
into custody.
constructive custody, my lord. Officially arrested on 20th morning. And in fact, I was there.
Where does it come? Where is it? Is it the accepted position?
It is born in the confessional statement as well. It is an accepted position, my lord.
Accepted position.
In fact, on 19th, when the complainants and everyone went to search for the deceased, my lord, I was very much there along with them.
They had first lodged an FIR at Pasture Police Beat House.
What time was that?
It was in the morning, my lord, around 11 or 12 o'clock. Then from Pasture Beat House, they told that since the place of occurrence emerges from Police Bazaar, so you have to lodge an FIR in Sadar Police Station. So evening, approximately around 4 p.m., the FIR was lodged in Sadar Police Station.
On 19th.
On 19th itself.
Then how is it that he got arrested at 9 o'clock in the morning?
Since morning, he was there with the search team of all the friends, my lord.
Bernard.
Yes, my lord.
Along with the police, he
Along
was
with
under
the police.
constructive custody, I would submit. That is an admitted position that he was along with the police.
And you got arrested the next day.
The arrest memo says 20th of February, but he was with the police and the
With
entire
the
team
police
since
does not
19th.
mean he was arrested. Where did he sleep at night on 19th?
Where-
No, in the custody. That, my lord, 19th, I don't
Where
really.
is the arrest memo? I have seen it.
But the judgment says, my lord, that on 19th, I was in police custody.
You may have been accompanying the police, you may not have been in custody.
In
The
custody
judgment
is-
says you were in custody. Then it's impossible, Mr. Khan.
In fact, that is also another
It's impossible.
why the auto driver and the ransom call
So
also.
many mistakes. So many mistakes. We were eliminating everything by taking that. But if the postmortem report itself does not justify that,
If I may only read one more line, my lord, this is in connection with the auto driver, who is supposedly the last.
Lordship, so far as the inquest is concerned, I'm sure there was conducted
Sorry?
an inquest. Body was exhumed on 21st February 2006 at 3 p.m.
yes.
So, Your Lordship, the
3 p.m.
21st.
That you don't do the postmortem that day, you've done it the next day, there's no problem.
So for the cause
But
of
the doctor, the examiner writes in the postmortem report and writes and testifies to the effect that 2 days or 48 hours.
Lordship,
We give him another 24, 72.
Lordship,
It's the murder, the death, if the way that you put it, the death would only have been possible on 18th.
18th night.
On 18th night, the death would only have been possible, the way you put it.
Lordship, yes.
Now, the postmortem report and the thing, since it says only 48 hours, we can't stretch it to double the time. Generally, if it says 24 hours, we stretch it a bit. It said 48 hours, you stretched it by another day.
Lordship, but 2 days or off, there was some confusion.
No, that is clear. Even the judge reads it as 2 days or 48 hours.
48 hours.
The judge reads it that way. So therefore,
The handwritten version says or, my lord, that appears to be a.
no, whatever it is, the judge has read it that way. That we can't.
But Lordship, the fact remains that maybe in that point, he was not exact.
Someone died.
Someone died, yes.
Someone died. He was killed. But
Lordship, that part,
what you show us does not point out that they may be. They could be, but
so Lordship, this needs further corroboration because it's not so decisive.
what corroboration? What corroboration? Now, could the trial court, on the basis of these facts, so many anomalies, could the trial court have reasonably believed that trial court does not have to believe that they're innocent?
Lordship.
All that the trial court has to believe is that on the basis of the material, on a wholesome appreciation of it, that you could not prove their guilt beyond reasonable doubt. That doubt is there.
But Lordship, those doubts, as the Lordship has raised a very important question, that the statement Bonnie makes that he died on his lap, and that is contradicted.
Let me also start with where I started today.
Lordship.
That we take everything else to be irrelevant
Absolutely.
and start with graveyard.
Lordship.
Your graveyard theory is on 18th, it's not on 19th.
Absolutely, Lordship, yes.
Postmortem report. We can't stretch postmortem report to 18th. Postmortem report will stretch to 19th. We can't stretch it to 18th. There's a big difference between 48 hours and 96 hours. If it was 5 days, you could have stretched it to 7 days. If it is 1 day, you can stretch it to 2 days.
Well, Lordship,
But 2 days, you can't stretch it to 4 days.
Lordship, expert opinions are always tentative, Lordship. These are not
Approximation.
approximation.
They are approximation.
Absolutely, Lordship.
It cannot be. But that's,
There's a gap only of
there is room for doubt. And once there is room for doubt, it's not beyond reasonable doubt. We are not giving them a clean certificate. That's not our assessment.
No, Lordship, yes.
The exercise that we are doing, is there any doubt?
But Lordship, this doubt, Lordship, if I may just sum it, Lordship, this doubt, if we go to the cause of death, I agree, Lordship, that he should have been more circumspect in giving everything, more specific details. But he has not mentioned, Lordship, he has not mentioned this in his report per se. This is commonly in chief.
Which one?
The 48 hours or 2 days.
Yes.
He is not exactly spelled out in the report.
But he's spelled out in the cross-examination, he's spelled out in the postmortem report.
Lordship, he's spelled out in the in chief. In chief.
Yes.
In chief.
In chief,
Lordship,
which is
yes.
good. Why should I probe him on that? Once he has said what I want him to
That
say.
Lordship is correct. But Lordship, but if you go by the report itself, there's nothing as such mentioned there. So if you take report prima facie as a document, this could be maybe memory lapse or something is improved.
We are talking about personal liberty.
Absolutely, Lordship. I'm aware of it. Lordship.
We have to be absolutely certain. They don't require to do anything other than sow some seeds of doubt. And once you see that on 19th it was not possible, and the postmortem report cannot be stretched earlier than 19th.
Lordship, my submission would be, Lordship, this came out in chief, and this came out in chief. And the prosecution brought it, Your Lordship.
Yes.
This was not borne out even by the records. And nothing has been...
But it's there in the postmortem report also. He has corroborated what he had opined earlier. He had opined that died 2 days before. That is exactly what he corroborates in the chief.
Apparently, Lordship, it looks like, yes, I can't improve on this, but it's not so substantial.
It was a mistake on my part. I had not stressed on the nature of death
Lordship.
in the postmortem report.
Absolutely.
When I took the papers,
I was about to reply on
look
that.
at the time of death.
Lordship, I was about to reply on that. Nature of death. Lordship, then with the nature, if there is a conflict between nature in death and time of death, either. Which will prevail, Lordship, with that?
You see, both in a civil matter and a criminal matter, you are entitled to take mutually exclusive defenses. The doctrine of election comes at the time of trial. Now, over here, both on cause of death, there is some element of doubt. And time of death, they are clean. They go scot-free on time of death. So why should we take, when time cannot be fixed, their presence cannot be fixed, how will we take cause of death?
Lordship, at least the presence of felt, Lordship, so far 3 of them being present and the body being discovered at the behest of that. So the only gap, Lordship, I would like to fill in that gap, Lordship, by Section 8. Section 8 of the Evidence Act. The mental process, Lordship, the contradiction that Burnett makes, if I take a Lordship to PW 17, this is one aspect of it.
There's one thing which is inescapable, which is that irrespective of postmortem, irrespective of anything else, they individually admit that they were at the graveyard. They individually admit that they were there at or about the time of death. Whether it was yesterday or today should not matter in the circumstances. Because when I say that he died in my lap, he died in my lap, it should be taken at face value. The defense is not that I do not know how he died.
Absolutely not.
The defense is a positive defense. I do not know how he died. Date could have been relevant. But he died on my lap, date becomes irrelevant.
There are other aspects to it also, Lordship.
Yes.
Yeah.
So we'll go into greater detail. We just, since I read it, we'll go into whatever you want us to see. But that still remains the.
Lordship is correct.
Just that.
But Lordship,
Once you say that died on my lap,
Lordship, there's a very fundamental query.
and then
If that
time of
contradicts
death,
with
according to report, becomes
irrelevant. And Lordship will kindly appreciate, in 313, had it been the case he had admitted this, that he died on the lap, or he admitted the confession died on the lap, things would have been different, Your Lordship. Had he admitted that yes, it was a case of dying in the lap.
No, but in 13 he does not contradict it either.
Lordship, he basically he's saying that 164 itself was not recorded. Now the question comes, Lordship, if the statement under 313 is false, Lordship, I'll not burden right now the court with the judgment. There's one judgment on that on 313, Lordship. Things remain same if you remain silent or you accept the prosecution story. In this case, had you accepted...
If you make a positive statement and you don't prove the positive statement,
Lordship,
then an adverse inference is...
106, Lordship, this is Lordship aware of it. Now, had the situation been died on his lap, then all other questions will lie very heavy on the prosecution, Your Lordship. That he admits it could be a case of cause of death could have been very different. No, he denies 164 being recorded. In cross-examination of the PW32 magistrate, no whisper has been made that this, as Lordship is rightly put that query, whether statement was recorded, whether time was given, whether he was signing or there, nothing has been done in the cross-examination. So that they escape, Your Lordship. Then he chooses not to bring himself under 365 as a defense witness. He loses the chance on oath. We could have got a chance to cross-examine that. Then he gets final chance in 313. He disowns 164. Now, here, Your Lordship, the law is very settled. If you succeed, if you agree with the prosecution story, and if that favors you, then reasonable doubt is badly shaken for the prosecution, Your Lordship, because he's speaking the truth. Under 313, there are two options. You can speak truth and you can lie also. And you are liable for perjury. If he spoke the truth, he would have got the advantage. Now, he chose to disown 164. That means he's disowning that he died on his lap. Now, if he's disowning that he died on his lap, it's apparently a false statement. The moment it's a false statement, that's an additional circumstances.
How is it a false statement?
Lordship,
If he disowns died in his lap, how is it a false statement?
First, Your Lordship, his statement died on his lap is an oral statement that contradicts with postmortem. No, if
Or cause of death.
Lordship,
If you take his denial in 313, and what goes is that his presence with the victim
yes,
at the place of occurrence at the relevant time, all of it goes.
absolutely.
So you can't just pick and choose.
No, Lordship, I'm not choosing.
You are only picking and choosing manner of death.
Lordship,
But if the 164 statement has to go, then the admission that he was with the victim
Also.
at the place of occurrence at a particular time, all of it goes.
absolutely correct.
And we can't pick and choose.
Definitely you can't pick and choose. Lordship, here the question is whether the first thing is this, how does he overcome 164? Magistrate statement clearly passed the test of in chief and cross that she recorded it. He signed the document, and it is not the case that...
All right. Let us think about it. You also think about it, and we'll give you some time. Next time when we come, do it in greater detail.
Lordship,
Today we've done it on overall impression.
absolutely, Lordship.
Next time, you do it with greater detail. They will also get a chance. But please concentrate more on facts than on law.
Lordship, on facts.
Because-
Lordship, I want to go on facts.
Matter is
Section,
done on facts.
section 80, Lordship.
Or
Section,
whatever law you throw at us, we'll be able to discard it.
Lordship, is-
That
Saying
will
it
be
doesn't
later, my lord.
disagree. I agree with
it
them.
doesn't. Lordship, that's why I'm not relying on his judgment. Only Lordship, only on a limited query that he said died on his lap, and there is a medical evidence that directly over.
Yes, that is the only thing that disturbs us.
Lordship,
Died on his lap is a positive statement,
Lordship,
which he does not come out of.
absolutely. But only in this particular
He came out
aspect,
of it
Lordship.
in 313. He came out of it in
Did
313.
not. He did not. That we will disbelieve. We will not take it for granted that a judicial magistrate who has no axe to grind will record a wrong statement against a person that he or she is not connected with. That will breathe anarchy into the system.
Absolutely, Lordship. Lordship, had that been the case, maybe then our case is shaken. But that has passed the test, Lordship. The fundamental issue is recording of the statement, dying on the lap, and it has passed the test.
Recording the statement we will hold. And that is why we add this thing, that if the recording of the statement
Yes.
is died on the lap is a statement, then time, everything
Becomes irrelevant, Lordship. I think I'll satisfy on that, Lordship.
Let us see. Let us see. We have to give them a chance also.
No, absolutely, Lordship.
Because this one factor, I must confess, had not crossed my mind, the time of death. But if they can still take advantage of time of death,
Absolutely, Lordship.
notwithstanding 164 remaining, then so be it.
But still, the larger issue is the
We are not
Lordship.
happy either way.
Lordship,
But ultimately, a life is lost. We have to see every single aspect of the matter. If in case they are actually
You must also remember the victim's life has been lost here also.
yes, my lord. Since the victim has lost his life, his family is suffering. So if these people, the respondents herein, if they are really guilty, then, my lord, being an officer of
Unfortunately, what we do over here is we do not go about really guilty. We go about
benefit of that.
assessing what may have happened without having the advantage of being present or seeing.
correct.
On the basis of material produced before us, we imagine ourselves to be at the place of occurrence, at the time of occurrence, and render judgment. All right?
Indeed,
so
my
we
lord.
imagine ourselves to be there as if we are seeing that this is happening on the basis of the material produced before us, ex post facto.
Absolutely, Lordship.
So that is the drama that we indulge in.
My lord, that happens, but it's just that
Lordship,
we will have to
take
keep
the other
in
way.
mind.
Lordship has dealt with so many POCSO matters. We have never come across one case of direct evidence, everybody seeing the actual act of commission. But the law has been crystallized so that how do we corroborate the defense, the victim's statement? There also, Lordship, there is no direct evidence. So I'm not saying that we can draw an analogy here, Lordship, but at the best we can come very close to the narrow gap between the three of them being present and the body being exposed by them.
that
So,
would be-
so Lordship, I want to fill that particular gap. That gaps has been filled by PW 17. It starts by PW 17 and Section 8 takes care of that, Lordship.
17, 18, 25 or 26.
My lord,
25,
18
Lordship,
and
25, 26 are the ones the witness and 25 is the IO. It covers 27, Lordship. 27 is the Evidence Act. But Section 8 will be very crucial, Lordship, if I read out the facts.
Very well, very well. When, madam?
My lord, if it would be convenient on 1st, my lord, because since we have already started
First.
1st August, my lord, there are 2 division bench on that day as well, my lord. Custodial death matter is coming up on 1st.
What matter is coming up on?
Custodial death matter, my lord.
Compensation matters.
Oh,
That will
not take much
that will
time.
much take
Hardly anything. Very well. By then we would have had a new judge and therefore this bench will be an irregular bench then.
But it was an honor and pleasure, Your Lordship, to appear before this bench always.
Yes. The thing is to do it responsibly.
Absolutely.
My lord.
You know, you have to take what is relevant, what is irrelevant, because everyone needs justice.
Lordship,
Justice has to be to the accused.
absolutely, Lordship.
Justice has to be
Absolutely,
to the
absolutely,
family of the victim.
absolutely.
And
But Lordship, personally speaking, what is disturbing my conscience even is that part is the body, 3 of them being there and the body being discovered by one of them. Irrespective of the technicalities of 27, eyewitness, we don't want to go into that. In the middle, Lordship, in the middle, that part has remained gap. And police could not have, Lordship will kindly appreciate, one part of the difficulty of investigation is, police could not have created an evidence there. You would have been exposed and a witness would have created. That is a gap that has to be filled by circumstances.
The impression is they are definitely involved.
Yes.
Absolutely correct, Lordship. That's why court is.
How do we affix guilt?
Lordship.
How do we substitute
Lordship,
proof?
Lordship, my respectful submission is, Lordship.
How do we substitute
Lordship,
proof for impression?
Lordship, my respectful submission is this: the murder weapon, except for the technicalities of law, has been discovered at the base of one of the accused.
Technicalities of the law very important.
No, Lordship,
Very important.
Lordship is correct.
Time-tested rules.
Lordship,
You cannot just forget the technicalities for this and remember the technicalities for that.
Since your lordship will get some more time, we will also get some more time, and your lordship is also reading the file very thoroughly. So one particular aspect which needs to be kept in mind is, my lord, the body is exhumed on 21st, then is the police not
Is there
bound
evidence
to...
that they lead to the body? No.
Yes,
No,
yes,
Lord-
yes, Lordship, yes.
No, my lord, the PCN has made video recording of the entire situation, and the PCN
That is a different part of it.
has stated that we did not see Bernard showing the place from where to exhume. Section 27 statement is also not there, my lord. The PCN video recording also, it was never played by the prosecution inside the courtroom. The PCN witness says that the Bernard did not show the exact place where the body has been buried. And my lord, if a body is being recovered from a particular place on a particular date, is it not the duty of the police to examine the entire place of occurrence, especially in a circumstance when it is a public place, my lord, it is open for every single person?
Inquest report will speak for itself.
And my lord, rope is nowhere there in the inquest report. That was recovered subsequently on 24th of February, tentatively.
We keep it on 2nd or 3rd, madam, not on 1st. 2nd or 3rd?
Lordship.
My lord, second.
2nd.
Lordship, in this case, we just assess the court, Lordship. Final principles of appreciation of evidence is involved.
Yes.
And there are times where it may appear on the face contradictory, Lordship, but we have to
Yes.
isolate both the principles.
You cannot.
As Lordship says
You
that,
cannot,
Lordship is
give reason and logic go by on a holiday.
absolutely Lordship.
All of them have to be seen together with the rules. Sometimes the rules may not fit.
Absolutely Lordship.
Sometimes the facts may not fit. So we must see to what extent.
So there are principles of law, Lordship, maybe we require to address that.
Judgment is really unreasonable, my lord, then yes, definitely it is for this honorable court to
No, we don't have to go by that. If only this part is relevant and the judgments get influenced by all the irrelevance, then the judgment is unreasonable. We know at the end of 18 years, madam, we will not be taught on how to assess.
We have nobody, my lord, to teach because your lordships have been there.
Lordship, second. Okay.
2nd. Yes, follow the next matter.
That's
Oh. Just give this back to them that they can. Have they filed a compilation? They have not. But the judgment that they give, keep those books ready on the next day so that.